Are we live? We're live. So, where hearsay exceptions when the declarant unavailability is immaterial within evidence, clearly, and page 40. The following exceptions to the hearsay rule do not require that the declarant be unavailable. Those include excited utterances, an out-of-court statement relating to a startling event made while under the stress of excitement from the event, i.e. before the declarant had time to reflect upon it, is admissible. And there's an exam tip here that sometimes a failed dying declaration may succeed as an excited utterance, for example, where the declarant is available or had some hope of survival. Present sense impressions. A present sense impression is a statement that describes or explains an event or condition and is made while or immediately after the declarant perceives the event or condition. There is little time for calculated misstatements. And the contemporaneous nature of the statement makes it reliable. Excited utterances versus present sense impression. There's a comparison chart here where excited utterance statement relates to a startling event, whereas the present sense impression statement describes or explains an event or condition. The event or condition need not be startling. And then for excited utterances, the statement must be made while still under the stress of excitement from the event. Depends on circumstances. Whereas with present sense impressions, the statement must be made while or immediately preceding the event or condition, strict timing requirement. Exam tip, the excited utterance and present sense impression exceptions sometimes overlap. If a statement in an essay fact pattern appears to meet the requirements of both exceptions, go ahead and analyze the statement under both of them. You don't need to pick just one. Present state of mind, a statement of the declarant's then existing state of mind, for example, motive, intent, or plan, or emotional, sensory, or physical condition is admissible. It is usually offered to establish a person's intent or as circumstantial evidence that the intent was carried out, except as to certain facts concerning the declarant's will, however. What's that all about? A statement of memory or belief is not admissible to prove the truth of the fact remembered or believed. Declarations of physical condition. There are two hearsay exceptions involving statements of physical condition. Statements of the declarant's present physical condition, regardless of the purpose for which the statement is made, and statements made for the purpose of for which the statement is made, and statements made for the purpose of obtaining medical diagnosis or treatment. Declarant's present bodily condition. A spontaneous declaration of a declarant's own present bodily condition is admissible as an exception to the hearsay rule, regardless of whether it was made for the purpose of diagnosis or treatment. Statements made for diagnosis or treatment includes past conditions. A statement that describes a person's medical history, past or present symptoms, or their inception or general cause is admissible as an exception to the hearsay rule if it was made for and was reasonably pertinent to medical diagnosis or treatment. Usually a declarant will be describing her own condition, but this is not required. For example, the declarant may be seeking medical assistance for a family member. Statements falling within this exception are usually made to medical personnel, but this is not an absolute requirement. If a declarant tells an emergency room physician, "I was stabbed with a kitchen knife, my roommate did it," only the first portion of the statement is pertinent to the diagnosis or treatment. Note, however, that many federal courts will admit a statement in which a child abuse victim identifies his abuser in the course of treatment. Remember that contrary to the majority state view, declarations of past physical condition made to a doctor employed to testify are admissible under the federal rules. Records of a regularly conducted activity, business records. Any writing or record made as a memorandum of any act or transaction is admissible in evidence as proof of that act or transaction. Under the federal rules and modern statutes, the main requirements for admissibility are as follows. Note, however, that under the federal rules, even an otherwise qualifying business record may be excluded by the court if the opponent makes a showing that the circumstances of the writing indicate a lack of trustworthiness. Business includes every business, organization, occupation, or calling, whether or not for profit. Entry made in regular course of business. To be admissible, it must appear that the record was made in the course of a regularly conducted business activity and that it was customary to make the type of entry involved. For example, the entrant had a duty to make the entry. Self-serving accident reports prepared primarily for litigation usually are inadmissible. Generally, police reports are not admissible against a criminal defendant under the business records exception. Personal knowledge. The business record must consist of matters within the personal knowledge of the entrant or within the knowledge of someone with a duty to transmit such matters to the entrant. Exam tip. Business records often present a multiple hearsay problem. Watch for fact patterns involving police reports or other incident reports that contain statements from bystanders who generally are not under the business duty to convey information to the police. Although the report itself, the outer hearsay, the entrant's attestation that the entrant's assertion that the bystander made these statements may qualify as the business record. The bystander's statements within it, the inner hearsay, do not and will need to fall within some independent hearsay exception or exclusion. For example, statement by opposing party. On the other hand, if the report merely contains the entrant's own observations or statements of persons under a business duty to report the information, the entire report may be admissible under the business records exception. Entry made near time of event. The entry must be made at or near the time of the transaction. Authentication. The authentication of a record must be established. This can be accomplished by the custodian, 1, testifying that the record is a business record, or 2, certifying in writing that the record is a business record. Business records may be used to prove the non-existence or non-existence of a matter if it was the regular practices of business to record all such matters. Recorded recollection. If a testifying witness's memory cannot be revived, a party may introduce a memorandum that the witness may adopt it at or near the time of the event for admissibility requirements. The record itself is not received by the jury as an exhibit. It must be read to the jury. That's recorded recollection. And I might highlight that actually because I don't think I have a note card for that, and I think I should. Records and reports. Public policy and reports. Public records and reports. These of the office or agency. 2, records of matters observed, proceedings, or 3, in criminal actions and against the government investigation authorized by law. The writing must have been made by and within the scope of the duty of the public employee, and it must have been made at or near the time of the event. Note, however, that an otherwise Qualifying public record may be included by the court if the opponent makes a showing that the circumstances of the writing indicate a lack of trustworthiness. Exam tip. Police reports that do not qualify as business records may be admitted under the public records and reports exception. Even the officer's opinions and factual, not legal conclusions would be admissible under this exception. Be careful, however, to test the statements of others contained in the report to make sure they are admissible under a hearsay exception. Otherwise, those statements will be excluded even if the report is admitted. Exam tip. Remember that public records and reports generally are not admissible against a defendant in a criminal case. This means that investigative reports by the police, FBI, and other agencies are inadmissible in this situation. Records of vital statistics. Records of vital statistics are admissible if reported to a public office in accordance with a legal duty. Statement of absence of public record. Evidence in the form of testimony or a certification from the custodian of the public records or other qualified person that she has diligently searched and failed to find a record is admissible to prove that the matter was not recorded or inferentially that the matter did not occur. Note, however, that a criminal defendant has a right to confrontation and may demand the presence of the person who prepared the certification. Thus, in the criminal case, this type of evidence is admissible in the form of certification only if the prosecution notifies the defendant at least 14 days before trial and the defense does not object in writing within 7 days of receiving the notice, unless the court sets a different timeline. Judgments. A certified copy of a judgment is always admissible proof that such judgment has been entered. Prior criminal conviction, felony conviction admissible. Under the federal rules, a judgment of a felony conviction is admissible in criminal and civil actions as an exception to the hearsay rule to prove any fact essential to the judgment. In a criminal case, however, the government may use the judgment for this purpose only against the accused and may be used only in prior criminal acquittal excluded. The exclusionary rule is still applied to records of prior acquittals. Judgment in formal civil case. A civil judgment is clearly inadmissible in a subsequent criminal proceeding and generally inadmissible in subsequent civil proceedings. Ancient documents. Judgments, there's like 3 subpoints here for prior. A certified copy of a judgment is always admissible proof that such judgment has been entered, but there's 3 numbered enumerated kinds here. Prior criminal conviction for felony conviction is admissible, but prior criminal acquittal is excluded, and judgment in formal civil case is fairly inadmissible. So for ancient documents, under the federal rules, statements in any authenticated document prepared before January 1 of 1998 are admissible. Like my birth certificate. Documents affecting property interests. A statement in a document affecting an interest in property, for example, a deed, will, etc., is admissible if the statement is relevant to the document's purpose. However, the exception will not apply if later dealings with the property are inconsistent with the truth of the statement asserted or the intent of the document. That's documents affecting property interests, deeds, wills, whatever. Learn treaties. And this I never thought was actually admissible, but treaties are admissible as substantive proof under the federal rules if called to the attention of or relied upon by an expert witness and established as reliable authority by the testimony of that witness, other expert testimony, or judicial notice. Reputation. Reputation evidence is admissible under several exceptions to the hearsay rule as evidence of the following: character, personal or family history, land boundaries, and lastly, a community's general history. Family records, statements of fact concerning personal and family history contained in family Bibles, jewelry engravings, genealogies, tombstone engravings, etc. are admissible. Other published compilations are admissible if generally used and relied upon by the public or persons in a particular occupation. So I can skip the next table because I already read all of these hearsay exceptions when the declarant's availability is not material to the determination to accept hearsay. There's a residual catch-all exception of federal rules for a hearsay statement that is not covered by the specific exception to be admitted. The federal rules provide a catch-all exception, which requires that the hearsay statement possess circumstantial guarantees of trustworthiness, that the statement be strictly necessary, and that notice be given to the adversary as to the nature of the statement. Constitutional issues. Under the Confrontation Clause, a hearsay statement will be admitted even if it falls within a hearsay exception when Romanet 1, the statement is offered against the accused in a criminal case. Romanet 2, the declaration is unavailable. Romanet 3, the statement was testimonial in nature. And Romanet 4, the accused has no opportunity to cross-examine the declarant's testimonial statement prior to trial. However, the defendant forfeits his right of confrontation if he committed a wrongful act that was intended to keep the witness from testifying. Testimonial statements made in the course of police interrogation. Whether a statement made in response to police interrogation is testimonial depends on its primary purpose: to aid in an ongoing emergency, not testimonial. If the primary purpose of police interrogation is to enable the police to help in an ongoing emergency, statements made in the course of the interrogation are non-testimonial. Example, 911 call during ongoing crime. In determining whether an ongoing emergency existed at the time, relevant factors include 1. The nature of the dispute, public versus private. 2. Whether the perpetrator is still at large. 3. The scope of the threat to the victim and to the public. And 4. The type of weapon involved. I wish I remembered the case where the main case is comes. But anyway, that's your ongoing emergency test. And to establish or prove events for later prosecution - testimonial, when the primary purpose of the interrogation is to establish or prove past offense potentially relevant to a later criminal prosecution, statements are testimonial. For example, statements to police describing crime after it has concluded. On the other hand, statements by a young child abuse victim to a school teacher about the abuse are not testimonial because the primary purpose of the conversation is protection of the child, not prosecution of the perpetrator. So, affidavits or written reports of forensic analysis. So this is all coming under the testimonial statement, which is coming under F, constitutional issues, which began with the Confrontation Clause. And so I'd like to know the relationship. Like, how did we get this mapping, right? Under constitutional issues comes the definition of testimonial. And what I find also is interesting is that I'm not being tested on this. It says if testimonial isn't even a word, that it needs to be defined or exists. So I'll read this. Affidavits or written reports of forensic analysis. Affidavits, certifications, or other written reports summarize the findings of forensic analysis and have the effect of accusing a targeted individual of criminal conduct. For example, fingerprint test results are testimonial and may not be admitted unless the defendant previously had an opportunity to cross-examine the author of the report. The testimony of the analyst supervisor who was not involved in the testing is not sufficient to admit the results. However, such reports may not be used for a hearsay purpose. Specifically, no confrontation violation occurs if the occurs if the forensic expert, while testifying as to her independent analysis of data, makes only a general reference to a non-testifying analyst's report. Due process rights. New section under the constitutional issues section is that hearsay rules and other exclusionary rules cannot be applied where such application would deprive the accused of her right to a fair trial or deny her right to compulsory process. So this table, showing the non-hearsay on the left and the hearsay exceptions on the right, is basically created to show of the hearsay, well, when the declarant's availability is relevant, right? So for non-hearsay, no such determination is made, but I think the criteria here, or at least the big ask here, is whether or not the non-hearsay has to be under oath. And that is about only applicable to prior inconsistent statement made under oath. Doesn't appear that that's a requirement under really much else. And then for hearsay exceptions, where unavailability is required, everything else, availability is immaterial. But there's 5 instances when unavailability is required under these hearsay exceptions, and that's 1 through 5: former testimony, dying declaration, statement against interest, statement of personal or family history, and statement offered against party procuring declarant's unavailability. So, done looking at that. I mean, availability is immaterial for excited utterance, present sense impression, present state of mind, present physical condition, statement for medical diagnosis or treatment, recorded recollection, business records or absence thereof, public records and reports, market reports, family records, reputation, learned treaties, documents affecting a property interest, ancient documents, judgments of prior convictions, and records of vital systems. One of the second to last, if not the last section of this bar prep book is about procedural considerations. The burden of proof. The burden of proof encompasses the burden of producing or going forward with the evidence and the burden of persuasion. Burden of producing evidence. The party who has the burden of pleading usually has the burden of producing or going forward with the evidence sufficient to make out a prima facie case. For example, create a fact question of the issue for the trier of fact. Once the party has satisfied the burden of the going forward with evidence, it is incumbent upon the other side to come forward with evidence to rebut the accepted evidence. Burden of persuasion, proof. After the parties have sustained their burden of production of evidence, the question is whether the party with the burden of persuasion has satisfied it. The burden of persuasion, for whether the party with the burden of persuasion has satisfied the burden of persuasion for civil cases is usually by a preponderance of the evidence, more probably true than not true, although some civil cases require proof of clear convincing evidence, which is a high probability, which I feel like is also 50-50, but maybe I'm wrong. The burden of persuasion for criminal cases is beyond reasonable doubt, which is like doubt. What's doubt? Some people say doubt is like 0%. Now, perceptions, my favorite. Didn't talk about this enough in an earlier recording. I almost want to skip it. A presumption is a rule that requires a particular inference be drawn from an ascertained set of facts. It is a form of substitute proof in the proof of the presumed fact is rendered unnecessary once evidence has been introduced to the basic fact that gives rise to the presumption. Effect, shift burden of production. A presumption operates until rebutted to shift the burden of production to the party again. A presumption does not shift the burden of persuasion. The burden of persuasion remains on the same party throughout a trial. Rebutting a presumption. A presumption is contradicting the presumed fact. Once sufficient contrary evidence is admitted, the presumption is of no force or effect. Distinguished true presumptions are the rebuttable type described above. Be careful not to confuse them with inferences. A permissible inference may allow a party to meet his burden of production. Example, the adversary. Examples include the inference of negligence arising from re ipsa loquitur, and the inference that destroyed evidence was unfavorable to the spoliator, and the inference of undue influence when the will's drafter is also the principal beneficiary. Presumptions in criminal cases. The presumption of innocence in criminal cases is merely a permissible inference. The burden of production never shifts to the accused. Exam tip. Special considerations apply when true presumptions arise in the criminal context. The judge cannot instruct the jury that it must find a presumed fact against the accused. He must instruct them that they may regard the basic facts as sufficient evidence of the presumed fact. Exam tip. If, in a criminal case, a presumed fact establishes guilt is an element of offense or negates a defense, it must be proved beyond a reasonable doubt. Conclusive presumptions. Because it cannot be rebutted, a conclusive presumption example that a child under age 7 cannot commit a crime is really a rule of substantive law. So, specific presumptions. The following are common rebutable presumptions. This should really just come first because unless someone has any idea what is being said here, they're gloss over everything I just said, and the specific presumptions might give them a lens into what's being discussed. Legitimacy. Every person is presumed to be legitimate. Against suicide, when cause of death is in dispute, there's a presumption in civil cases that it was not suicide. Sanity, every person is presumed sane in civil and criminal cases until the contrary is shown. Death from absence, if a person is unexplainably absent for a continuous period of 7 years and he has not been heard from, he is presumed dead. Ownership of car, agent driver, proof of ownership of a motor vehicle creates a presumption that the owner was the driver or that the driver was the owner's agent. Chastity. Every person is presumed chaste and virtuous. Regularity. It is presumed that persons acting in an official office are properly performing their duties. Continuance. Proof of the existence of a person or condition at a given time raises a presumption that it continued for as long as it is usual with things of that nature. Mail delivery. A letter properly addressed, stamped, and mailed is presumed to have been delivered. Oh my God, last 2 pages. Solvency. A person is presumed solvent and every debt is presumed collectible. Baileys. Negligence. Bailey. Bail, apostrophe S. Bailey's negligence. Proof of delivery of goods in good condition to a bailee and failure of the bailee to return the goods in the same condition create a presumption that the bailee was negligent. Marriage. Upon proof of a marriage ceremony, a marriage is presumed valid. Conflicting presumptions. When 2 or more conflicting presumptions arise, the judge should apply the presumption founded on the weightier considerations of policy and logic. Choice of law regarding presumptions in civil actions. Under the federal rules, state law governs the effect of the presumption concerning a fact that is an element of a claim or defense to which, under the Erie Doctrine, the rule of decision is supplied by state law. Relationship of parties, judge, and jury. Allocation of responsibilities. In our adversarial adjudicative process, the focus is on the party's responsibility to frame the issues in the litigation and to assume the burden of proving the issues he has raised. The trial judge's primary responsibility is to superintend the trial fairly. As a general rule, questions of law are for the trial judge to determine, and questions of fact are for the jury. Preliminary determination of admissibility. In most cases, the existence of some preliminary or foundational fact is an essential condition to the admissibility of proffered evidence. The federal rules distinguish preliminary facts to be decided by the jury from those to be decided by the judge on the ground that the former questions involve the relevance of the proffered evidence, while the latter questions involve the competency of evidence that is relevant. A, preliminary facts decided by jury. B, preliminary facts decided by judge. For those decided by the jury, examples of preliminary facts to be decided by the jury include agency, authentication of the document, credibility of a witness, and personal knowledge. Preliminary facts decided by the judge is facts affecting the competency of the evidence. The federal rules permit the trial judge to consider any non-privileged relevant evidence, even though not otherwise admissible under the rules of evidence. Most state courts, however, hold that the rules of evidence apply in preliminary as much as in any other phase of the trial. Thus, only admissible evidence may be considered. Presence of jury. Whether the jury should be excused during the preliminary fact determination is generally within the discretion of the trial judge. The jury must be excused if 1, the hearing involves the admissibility of a confession, or 2, the defendant in the criminal case is testifying at the hearing and requests that the jury be excused. Testimony by accused does not waive privilege against self-incrimination. An accused may testify on the surrounding an allegedly illegal search without subjecting herself to testifying at trial. That's interesting. How exactly does that get done? Judicial power to comment upon evidence. A judge may comment on the weight of the evidence in federal courts, but generally not in state courts. And E, power to call witnesses. A judge may call and interrogate witnesses on her own initiative. Rulings. The trial judge has an obligation to rule promptly on counsel's evidentiary objections and upon request to state the grounds for her rulings. Instructions on limited admissibility of evidence. If evidence is admissible on a limited basis, the judge must, upon timely request, restrict evidence to its proper scope and instruct the jury accordingly. So, I wanted to just use this time to just revisit the fact that I skipped the privileges. I figured, I've heard it enough, but you never really hear it enough. Certainly the attorney-client privilege is, really incredibly important. So, before we went into hearsay, we skipped through really a lot. And I think state really controls everything. So let's actually just read the attorney-client privilege. Communications between an attorney and client made during professional consultation are privileged from disclosure. The important elements of this privilege are attorney-client relationship. The client must be seeking professional services from the attorney at the time of the communication. Disclosures made before the attorney accepts or declines the case are covered by the privilege. Corporations are clients within the meaning of the privilege, and statements made by corporate officials or employees to an attorney are protected if the employees were authorized by the corporation to make such statements. Confidential communication. To be protected, the communication must be confidential. Example, not intended to be disclosed to third parties, but representatives of the attorney or client may be present without destroying the privilege. Otherwise, communications may be made in the known presence of hearing of a stranger are not privileged. communications through agents, communications made to third parties, example, secretaries, messengers, accountants are confidential and covered by the privilege if necessary to transmit information between the attorney and client. Exam tip. A favorite exam topic involves communications between a client and a doctor during an examination made at the attorney's request. Be careful, the doctor-patient privilege infra does not apply because no treatment is contemplated. The attorney-client privilege will apply, however, as long as the doctor is not called as an expert witness. No privilege where attorney acts for both parties. Where an attorney acts for both parties to a transaction, no privilege can be invoked in a lawsuit between the two parties, but the privilege can be claimed in a suit between either or both of the two parties in third person. Client holds privilege. A client holds a privilege, and she alone may waive it. The attorney's authority to claim the privilege on behalf of the client is presumed in the absence of contrary evidence. Privilege applies indefinitely. The attorney-client privilege applies indefinitely. The privilege even continues to apply after the client's death. When the privilege does not apply, there is no privilege if the attorney's services, 1, were sought to aid in the planning or commission of something the client should have known was a crime or fraud. 2, regarding a communication relevant to an issue between parties claiming through the same deceased client. 3, regarding a communication relevant to an issue between parties claiming through the same deceased client. 3, for a communication relevant to an issue of breach of duty in a dispute between the attorney and client. And 4, where the client has put the legal services at issue in the case. F, attorney's work product. Although documents prepared by an attorney for his own use in a case are not protected by the privilege, they are not subject to discovery except in cases of necessity. Limitations on waiver of attorney-client privilege and work product rule. A voluntary disclosure, and I did read this, and then it just dumps you into physician-patient privilege, which I did read also, and it's like almost exactly the same. I stopped at psychotherapist, social worker, client privilege. Remember that when a psychiatrist is a doctor involved, the applicable privilege is the psychotherapist client privilege, which is more widely accepted in all proceedings than is the physician-patient privilege. Because in the psychotherapist social worker client privilege, the United States Supreme Court recognizes a federal privilege for communications between a psychotherapist, psychiatrist, and psychologist, or licensed social worker and his client. Thus, the federal courts in virtually all the states recognize a privilege for this type of confidential communication. In most particulars, this privilege operates in the same manner as the attorney-client privilege. Marriage comes with the spousal immunity and confidential marital communications. And rather than read that section, I'm just going to read the table that compares them both. So for spousal immunity, one spouse cannot be compelled to testify. Oh, I already read this. One spouse cannot be compelled to testify against the other spouse in any criminal proceeding. Only the witness spouse may invoke the spousal immunity. For example, the party spouse cannot prevent the witness spouse from testifying, and the privilege can be claimed only during marriage, but covers information learned before and during the marriage. Whereas the confidential marital communication privilege involves communications made in reliance upon the intimacy of the marital relationships. Those are privileged. The privilege applies in both civil and criminal proceedings. Both spouses have the privilege not to disclose and to prevent the other from disclosing a confidential marital communication. The privilege survives the marriage, but covers only statements made during the marriage. So that's where I'm going to end this.